We hope you enjoy this episode of the Modern Divorce Podcast. But first, an important message for our listeners.
Hi, this is attorney Billie Tarascio, and my partner Julie and I have created a resource for you if you are representing yourself in family court. No one should go into family court without knowing the basics, and we will teach you everything you need to know at Win Without Law School to represent yourself with confidence. We'll teach you how to get exhibits in, how to draft your pretrial statements, and how to speak to the judge so the judge will listen. We'll teach you how to defend against false accusations and everything you need to know to be an effective advocate, both if you're negotiating or if you're presenting evidence. Don't wait. Go to winwithoutlawschool.com. We can help you. Hello and welcome to another special edition of the Modern Divorce Podcast. I am your host, Billie Tarascio, and today I am joined by the man of the hour, my favorite attorney currently on this day, Richard Lyons. He is spearheading the civil lawsuits that have been filed against the Gilbert Goons and Chandler School District. Richard, welcome to the show.
Thank you for having me, Billie. I appreciate it.
I'm so happy that you're here. So I started following the Gilbert Goons situation really early in December and knew that there was civil liability and was talking to different lawyers and was looking at different lawyers. And when you and I talked, it was so clear that you were the lawyer to take these cases. You got it. You understood it. You knew the history. You saw the vision. You were creative. You were aggressive. I was so excited to connect these victims with you, or some of them.
Well, I appreciate you doing so. Part of it, I guess, a little bit of it maybe might be personal. I grew up here and I graduated from Mountain View High School down the road. I've heard what happened to Preston in October, and I just kept up with local reporting and saw what was going on in the Gilbert area, in an area where I grew up, and I was horrified by it, just as a citizen, as a parent, as just as a human being. I was mortified. And so I was following it, and I'm a trial lawyer. I've been a trial lawyer for 23 years. I used to defend school districts from civil rights claims 20 years ago.
Good.
I've sued police departments, and this is the kind of work that I do professionally. And so I had, I guess, some personal motivation, and my firm takes these cases on. And so it was something that I really wanted to do, and I'm happy to do it. Happy to try to get justice for some of these citizens who have been attacked, and especially the ones who aren't getting justice from the civil justice system, or at least not as much as they ought to be.
Absolutely, without a doubt. And you've helped tell their stories in a different way as well. Your complaints really outline from their perspective and from a legal perspective why they should be held accountable. That's not the same type of reporting that we get from the Arizona Republic. It's not the type of information we're getting from press conferences from Rachel Mitchell. So it's been, I think, really exceptional for the community to see what it is that you have to say in these complaints.
Well, I appreciate it, and I've put in a lot of hours on it, and my clients have extended themselves. It's not easy to do what they're doing and to put their name out there. There's still some attackers who have not been arrested, who are not behind bars, and there is still some fear in the community and among my clients about what might happen. But they're taking a stand, they're asserting their rights in the only way that they possibly can. And so kudos to them, and the opportunity to kind of lay out in writing, here are the facts, here's the law, here's how the facts apply to the law, and here is exactly why my clients get justice in civil court. It has to be laid out, and so I'm just doing my job and trying to make it as clear as I can.
I think you absolutely have. So 3 lawsuits at this point have been filed, 2 on behalf of one victim and 1 on behalf of a different victim, but they're all involving this Gilbert Goons situation. And if somebody is listening to this podcast for the first time, can you give us a brief overview of what are the Gilbert Goons and why have they been sued?
So from what I've heard, and from people I've talked to, from witnesses, and from what I've read in the paper, the name itself started to be used more than a year ago. And it was commonly known by teenagers in the area that there was a group of kids going out and just randomly assaulting other teenagers, unsuspecting teenagers, and circulating the videos on social media. And so the name itself didn't become known in the community until somewhat recently, but the name Gilbert Goons has been within the vernacular of teenagers in the area for months and months. And there was a real palpable fear of them. And I've talked, my clients, I've talked to them, and they understood that there was a group of teenagers that was going out and just tuning up unsuspecting, totally innocent teenagers for no reason whatsoever. And so they aren't like isolated attacks. It's the same group of kids going out and attacking unsuspecting teenagers. The tort of civil conspiracy.
Mhm.
It occurs when two or more people make an agreement to commit an unlawful act. And if the agreement exists and one of those participants goes out and commits the unlawful act, they're both on the hook for it. And it doesn't need to be an explicit agreement. The Gilbert Goons don't have articles of incorporation. You can prove a conspiracy by conduct. And so the fact that this group of teenagers, they have a Snapchat group, and the same group is going out weekend after weekend and assaulting kids and circulating a video amongst themselves, they have this agreement and they're doing it as a group. And it's a civil conspiracy. And so every time one of them goes out and tunes up a kid for no reason and circulates that video, they're all on the hook for it because they've all agreed, here's what we're going to do for whatever reason I cannot fathom. But that's what a civil conspiracy is. And that's why, anyway, go on, go ahead.
Okay, so in the initial complaint that was filed, I think I counted 48 defendants. Is that right?
I think so.
Okay, and those include the minor children and their parents, and sometimes they include children who are no longer minors, but their parents are on there, and includes one step parent. So I've got lots of questions about that, but the complaint has 6 different causes of action, 6 different counts. Are the parents only liable for some of those counts, or are the parents also liable for all of the accounts?
No, they're not liable for all the counts.
Okay.
They didn't commit assault and battery, but they're liable for the damages that their children cause. And one of the counts is statutory liability.
Yes.
If a parent can be a perfect parent, do everything right, if your kid goes out and shoplifts, then you're on the hook for it, up to $10,000. And you don't have a choice. It's Arizona law.
Mm-hmm.
Now it has to be malicious or willful misconduct. But if your kid goes out and commits a criminal act and causes harm or causes damages, you're on the hook for it. If you are a negligent parent, if you don't supervise, if the jury determines that you have not done your job as a parent, then you're on the hook for all the damages that your kid causes. And so only 2 of the counts are related to the parents. Every one of them, by virtue of the fact they're a parent or guardian, they're on the hook for 10 grand. If we can prove that these parents should have been monitoring their kids better and supervising, then they'll be on the hook for all of it.
Okay, so then it's possible that some parents will be found negligent and other parents won't.
Sure.
Okay.
Yeah.
All right. Now I want to ask about the step parent. There's a step parent named. Are they liable statutorily or under negligent supervision? Do they have a duty?
Yeah. The statute says parent or guardian. That's all.
So step parents are guardians. It doesn't have to be a legal guardian.
I don't believe it has to be a legal guardian. It's
Okay.
whoever lives at the home and supervises the kid.
Okay. All right. So the step parent is liable because they're a custodial guardian. They don't have to be a legal guardian. Is that correct?
Correct. Does not have to be a legal guardian if the child is being raised and reared by effectively a guardian at home. Then that guardian is liable, even though it may only be a step parent and not an adoptive parent or a legal guardian.
That is certainly interesting, especially to me as a family law attorney, because I talk about step parents a lot and their roles. And to know that they can have potential civil liability is good to know. People should know that. Now, what if I know in a criminal case where you have multiple defendants, you can have them turning on one another and you can give one a deal. In a case like this, that's civil, with all of these defendants named, can some of those defendants be dropped in exchange for their testimony?
Not in exchange for their testimony. Candidly, I don't know if I can do that ethically. I don't think I can. It's never occurred to me.
Okay.
It's something that I would not do. They can pay what they owe. The damages that we think they're gonna have to pay after a jury trial. But I'm not interested in cutting deals with anybody. It's not what I do. I take everyone who's civilly liable to trial and let a jury figure out who owes what.
Okay.
And in the case of a conspiracy, it's joint and several liability, and with negligent parenting and supervision, it's joint and several liability. And so if I get a judgment against 8 or 10 individuals, I'll collect against the one with the most money.
Right.
And let that person try to get contributions from the co-defendants.
Okay, let's talk about that for a minute. There are a number of different damage claims for the civil conspiracy complaint. What are the different ways that the plaintiff can be compensated? What are the different damages?
So there's what's called general damages, which is pain and suffering, inconvenience, humiliation, those sorts of injuries, and they're significant. What kid wants to get beat up in his childhood? It's scarring. To listen to I have one client who had to go overseas, and imagine having to do that in the middle of your high school career. The other kid still lives in town and continue to live in town and get harassed and threatened for 6 or 7 months until the goons started getting arrested. And so that's covered by general damages, the pain and suffering and those sorts of damages. There's what's called special damages, which is for medical bills and ER visits, that sort of thing. And then there's punitive damages. If you can prove that someone engaged in willful misconduct, then you can get punitive damages against defendants, whether they're minors or not. And so, I would hope that I would be able to get a punitive damages instruction to the jury against every one of the actual attackers in the case.
And you get to go through discovery in this process, correct?
I'm looking forward to it.
So
Yes.
that means you can subpoena Snapchat. You can subpoena. Go ahead.
I'll do my best. Some of this evidence is in the hands of the Maricopa County attorney right now. I'm sure I'm not going to be able to get some of it. I will try, but I'm gonna do what I can to get all the actual evidence from the filmers and from the ones that were exchanging the videos themselves. But I have all the evidence I need on the videos, and I'm looking forward to getting some of these defendants under oath and showing them the videos,
Right.
and having them identify the ones that I can't quite identify yet.
Right. Yeah. So I do want to ask, these defendants have a Fifth Amendment right not to incriminate themselves.
Right.
Usually that doesn't apply in a civil suit, right?
Well, they are welcome to take the Fifth Amendment, and I'm sure some of them will, because I'm going to be asking them about the attack on Rick Keener's son and about their involvement in it. I'm sure they're going to assert their Fifth Amendment privilege. They don't have a Fifth Amendment right not to identify people.
Right.
And not to explain whose idea was it to circulate this video, or whose idea was it to how did you lure this kid into this environment? There's so many questions I want to ask. I suspect they're going to assert their Fifth Amendment privilege repeatedly, maybe the entire time. And I'll probably have to fight with them and their attorneys to force answers out of them on some of those questions. But they do have a Fifth Amendment privilege not to answer questions that could implicate them criminally, even in a civil case. Now, the difference is the criminal jury never hears that they've asserted their Fifth Amendment privilege. They're just sitting there silent. In my case, if an attacker asserts his Fifth Amendment privilege, then the jury that hears the case hears him assert his Fifth Amendment privilege, and they can infer whatever they want from that. And so they're going to infer, at least most jurors that I've spoken to, they infer that the answer would have had negative consequences towards them.
Okay. Do you have the ability in a civil suit to take depositions of potential witnesses who are not named defendants?
I'd have to subpoena them.
But you can do that.
I can. Yeah, I can. I can serve subpoenas. They can fight them, but I suspect I'd be able to depose who I want to in the case.
Okay. What's so great about this is that victims can take justice into their own hands. They aren't waiting for Maricopa County Attorney's Office to talk to who they want to talk to, or don't talk to the victim, or they don't have to do that. They can be involved, and you can direct an entire strategy to collect information and share it, which is pretty cool.
Exactly. Yeah. When I file a lawsuit, I have subpoena power, and it's a useful thing to get information that I want that most other people cannot get. I'll be able to subpoena, serve subpoenas for all sorts of information that's floating out there that I want to find.
It's really wonderful. Do you have any idea? There is no specific damage amount claimed. Do you have any idea how much this total lawsuit might be worth?
I have no clue.
Okay.
Yeah, I truly don't know. All I've done is talk to my clients, and I've known about these cases specifically for about a month, and I just don't know. It's unfair for a lawyer to say early on these are very unusual cases.
They are.
And yeah, and you never know what the case is going to look like at the end of the day, and what claims are going to be made and what defendants are still in. Has anyone settled along the way? There's a lot to consider, and especially in a case where I may get punitive damages instructions, which I can ask juries to punish the defendant and convince others never to take that particular action, and so that obviously increases the value of cases.
One of the things that people have been bringing up that is not really related to this, but kind of is the Jennifer Crumley criminal conviction. Do you think that has any impact either on the jury pool or on your case at all?
No, I don't think it does. I don't know a whole lot about it. I believe that they actually gave a firearm to this kid, and they knew he had mental health issues.
Yes.
And I think that's what led to the manslaughter conviction. I'm certain she's getting sued civilly for negligent parenting, and I suspect her insurance provider, if she has one, ponied up all the money they had immediately upon a demand. But I don't think it has an implication here. I don't think so. I mean, I don't think there's any evidence that these parents actually facilitated the assaults or helped the assaults along. They were completely blind to what their kids were doing. And it's crazy to think that with reasonable parenting that they would have been blind, because there are drugs involved. There are more than just the videos that I attached to the complaint. There are videos there are pictures that have circulated with hard drugs on them. It's known that drug use was rampant, and alcohol use was rampant during some of these attacks. I have evidence in that respect, and so if the parents were providing those drugs, then maybe they would have some liability. But from what I've seen, it's more just a case of negligent supervision by these parents and having no clue what their kids were doing when they were going out. And I mean, if they monitored their Snapchat, they would have seen these assaults going on. And so how it just escapes me how a parent can be that absent for their teenagers. So, but fortunately, I'm going to have some of them under oath here shortly, and so I'll ask them.
Right.
And
what were you doing to monitor your kids?
I'll get details.
Right. Right. And people might come forward that say, I talked to the parents about this. I told them about this. They knew about it. That would be very valuable, wouldn't it?
If there are witnesses out there that would tell me that, I would love to hear from them.
If that's true, we need to know, because it makes a big difference if somebody actually knew their kids were involved in these things and they did nothing to stop it.
Yeah, I would love to know that.
Well, and some of the kids have been charged previously for this type of behavior. So certainly those parents had a heads up.
Well, Principal Lander had a heads up.
Right.
You know what's sad to think about, and this just occurred to me a little while ago. On August 18th, the night that Rick Keener's kid got attacked at the In-N-Out, a CUSD principal and a Gilbert police officer watched a goon video with a kid who participated in it. And so, 9-10 weeks before there's a murder, you have CUSD and Gilbert police watching. I'm not saying that the people who attacked Rick's kid had anything to do with Preston's murder, but they're all 1 or 2 degrees removed.
Well, they may have, right? Do we know that?
I don't know, and I certainly don't want to suggest that.
Right.
I truly do not. But these 2 adults were watching a goon video,
right?
And some from this group of kids who was going out attacking others indiscriminately, some from that group would commit a murder in 9 or 10 weeks. And you have to wonder, what if the principal made her son talk?
Right.
Or what if the principal reported like the law required her to do? And, would it have made a difference and stopped what was going to happen in a couple of months? And you can't know, and it's not subject of a lawsuit as far as I know. But it's just sad to think about.
Absolutely. And I am enraged today finding out that Principal Lander's stepson, who was absolutely involved in Rick Keener's son's attack, according to your evidence, will not face prosecution.
It's horrifying to think that a kid can threaten a classmate, and be there, be present, and run towards a fight with a fist. And the video proves it. And the victim testimony further proves it, and he's going to get away with no prosecution whatsoever.
They're not even going to try. They're not even going to try.
It makes no sense to, for assault in the state of Arizona, you don't have to hit somebody. You have to make that person fear for his safety. And that's exactly what Rick's kid told the cops that night that he was attacked, that this particular teenager was in on the attack, and he threatened me beforehand, and he followed through with it with his friends. And the video showed him doing it. Mm-hmm. And so why the prosecutor isn't, it's a gift wrapped assault conviction that the cop that was there that night could have arrested him and charged him with. And it didn't happen that night. And when Gilbert PD finally does the right thing and refers that case for charges, the county attorney says, no, I have better things to do. And what those better things are, I have no idea.
It doesn't look good. It doesn't make us, the public, happy. It doesn't give us any faith that you're going to do the right thing in Preston's murder.
Yeah, and well, it's one thing for this is not in isolation. This assault is not an event in isolation. It's not, in some town that's not Gilbert, that has not had this history, this recent history, and not had this murder, where, are the police and the county going to prosecute a kid who just kind of runs towards a fight with a cocked fist? Maybe not in any regular town in America, but you have him as part of half a dozen attackers. There's 5 others charged. It takes nothing to add him to the mix. And in this environment right now, where there was a murder, and these attacks were going on for months and months. And again, I'm not saying that the defendants in my case had anything to do with Preston's murder. I'm not saying that, but it was the environment, it was the videos and circulating the videos and conducting these attacks. This environment existed, and this was one of the attacks, and one of the attacks led to a murder, and how they're not being proactive in this case. I mean, you throw the book at everyone you can. You
Well,
would think
right.
you would think they would, but they're not. And it makes no sense to me, and it's sad. It's sad. And thank God for the civil justice system and civil courts, and someone may get away with making threats to teenage victims and letting letting fellow goons do the dirty work, and get away with it criminally. But there are civil claims that we'll make, and hopefully I make those stick.
Absolutely. So I want to talk about the liability of in and out police and the school.
The Gilbert police is not really a defendant. I served a notice of claim on them for the conduct of an SRO at Chandler Unified School District.
Mm-hmm.
And I don't know who owns him, candidly, for that employment purpose, whether it's Gilbert PD or Chandler Unified. Mm-hmm. I named him as an at-fault party. Chandler Unified dropped the ball. Now a school is not civilly liable for attacks that occur off school campus and outside school hours. There can be a threat from one student to another at school, but the minute they leave campus, the school's off the hook. So I'm not alleging that CUSD is responsible for the attack at the In-N-Out. They're just not. The case is called Dinsmore, Dinsmoor, in case any of your viewers want to look it up. But it's clear that the district's off the hook for that. But the district is required to provide a safe learning environment. And by knowing these threats existed, and knowing that there was a gun flashed at my client's kid, they have a responsibility to make sure that he has a safe place to learn. And they simply refused to provide it. They had evidence. The CUSD principal viewed the video of Rick's kid being attacked, knew that her son was there, and apparently was aware that her stepson was not going to be suspended or expelled or removed from that environment. And so it's beyond comprehension that they didn't do anything. They refused to take any action. They decided they'd move the principal's stepson to the other side of English class, and that's it. And so you have a 17-year-old junior in high school who's been threatened. He's had guns flashed on social media. He's been actually attacked and beaten by a gang of 8. And the school won't do anything to protect him at that school. And he's still in a room with his attackers, or at least one of his attackers. And so Rick did the only thing he could do, which was pull his kid out, because the school wouldn't protect him, and he wanted to protect his physical safety. And so the school's not on the hook for damages from that attack, mm-hmm. but they are on the hook for failing to create a safe learning environment and forcing Rick's kid to withdraw and shelter overseas and endure that nightmare that it really has turned into.
That makes a ton of sense. Makes a ton of sense that we should be able to expect to send our kids to school and that environment would be safe. And that if we made the school aware of a known threat, that they would take appropriate action. That is a reasonable expectation that we as parents should have.
There's a statute, it's ARS 15-841. And it says that if a kid actually brings a weapon to campus, or if he displays a weapon, then he can be expelled.
Yeah.
And the Ninth Circuit has said that displaying a weapon includes displaying a weapon on social media, mm-hmm. sending a text threat, mm-hmm. or a social media threat. In this case, Rick's kid got a gun texted to him from a kid at Campo Verde. There was a Snapchat group that the principal's stepson was a part of. And one of the kids from that Snapchat group sent an unmistakable death threat, a gun pointed at the camera. And so that came from a Snapchat group that these kids were a part of. And so, either of those kids could have been, any of those kids could have been expelled under ARS 15-841. I think it's subsection G of that statute says that if a student threatens physical violence on another student for the purpose of disrupting the learning environment, he shall be expelled for a year.
Wow.
Look up the statute. I read it again yesterday. And so if a kid cannot threaten another, now the qualification is to disrupt the learning environment. And so, the problem is if you invoke that statute, especially against a family with money, they are going to fight it. And it costs money to expel a kid. It takes time to expel a kid. It is not easy to expel a kid. It's a whole lot easier just to sweep it under the rug, pretend it never happened, and hope that kids stop threatening, hope nothing bad happens.
Right.
And that's what CUSD chose to do in this
Well,
case.
and even now, their message that they recently sent is that essentially implies that this was outside of their jurisdiction. And
well, the attack at In-N-Out was. I mean, that argument is well taken, but that's not what I'm claiming. That's not what the notice says. We're not claiming that CUSD had an obligation to stop the attack at In-N-Out, or the Gilbert PD did. The police are not guarantors of safety. You don't have a civil right not to be attacked. And so, that's a case against those goons that attacked him. But adults are responsible for taking appropriate action when that happens. And in this case, they didn't do anything. They didn't remove the attacker from school, and they left Rick's kid in that environment. And
so with regards to the police cannot be sued. I just want to make sure I understand, for failing to investigate these crimes, failing to press charges, failing to
Correct.
get these criminals off the street. There's no claim.
There's no claim. Police have qualified immunity. They're not civilly liable unless their conduct infringes on a known right to life, liberty, freedom of speech, freedom from unreasonable search and seizure, that sort of thing. You have no right. You don't have a constitutional right for the crime you allege that occurred to you to be investigated. Rick's kid did not have a constitutional right for his attackers to go be arrested that night. The police can decide they have better things to do. And unfortunately they did.
Wow.
And there's no claim to flow from that. A police officer can be on his way to a bank robbery and stop and investigate jaywalking. And the dead people in the bank can't sue the police department because there's no constitutional right not to be shot in a bank robbery by third parties. The police are not guarantors of safety.
Okay.
But once they decide to intervene, if a cop punched the jaywalker in the face,
Sure.
There's a Fourth Amendment claim.
Okay, so then what about In-N-Out? In-N-Out had many, 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 many instances of violence. Do patrons who are going to In-N-Out have a expectation that they will be free from attack at In-N-Out?
Yeah, there's a good case against In-N-Out to be made. I could have named In-N-Out perhaps in my case, but I had 48 defendants and I don't want 49. So we made the calculated decision. We'll give In-N-Out a pass on this one, but under the right circumstances, they're absolutely liable. All I know is the data that one of the news stations provided, which is dozens and dozens of calls, and not just to the In-N-Out, but to that shopping center that's around there. There are fights going on all the time. I know some In-N-Outs have security, and why that In-N-Out had security, didn't have security, I have no idea.
Okay.
Or maybe they did, and they literally did nothing ever.
Oh, so we don't know if there was security or not, because So far, they haven't been sued.
I have not sued them. Nope.
Okay. I want to ask about insurance companies. Usually in personal injury cases, you're looking at suing insurance, malpractice insurance, auto insurance. Is there any type of insurance that pays on these types of actions?
Typically, homeowners coverage will step in and pay.
Okay, but they don't have to be named. Like, do you begin negotiating with them? How does that work?
No, you never sue an insurance company. Well, we sue insurance companies for bad faith at my firm when insurance companies don't treat their insureds like they should. But again, so you sue an individual and the insurance company provides a lawyer, provides money to settle the case. If I sued one of these sets of parents who has homeowners coverage for negligence, and that insurance company decided not to provide coverage, then that would be a bad faith case by that parent against the insurance company. But we don't, just as a matter of course, you don't sue insurance companies.
So how will the homeowners insurance policies become aware and then get involved in the negotiations and make settlement offers? How does that work?
If the defendants who own homes are smart, they'll send notices of claim to their carriers.
I see. So if you get a judgment, you can't go collect it from the insurance company. The person who's insured has to opt into that coverage.
I guess, the insurer is duty bound to provide coverage. I mean, that you pay insurance premiums for that reason. And so if an insurance company, we're getting into insurance bad faith law, but if an insurance company knows or reasonably should know they need to provide coverage and they don't, then they're subject to bad faith. And these cases are easy enough for insurance companies to digest to where we wrote them that way. So they'll provide coverage for sure.
Okay. I understand. All right. And then is it possible, and we may want to leave this in or out, but is it possible if parents have all of their assets in trusts and LLCs that they are protected from liability?
No. Your damages are what they are. And if you get a $5 million judgment against you and you only have $1 million in insurance, the $1 million will pay and you owe $4 more. People can try to discharge debts in bankruptcy, but if you don't, if you have the money to pay the debt, you don't get it discharged.
Right.
So, you get big judgments against people if they happen to have money that's collectible, then happy days for me and my clients. Unfortunately, people with money hide it well. They tend to, and sometimes it's tough to find money that exists at the time that you file a case. There's the notion of fraudulent conveyance. If somebody knows they're going to get sued and sells a valuable piece of property for next to nothing, or conveys a business, or sells a home for less than it's worth, then not only are they liable for fraudulent conveyance, but sometimes the person who received the property and who paid next to nothing for it can be sued as well. So just there's a lot to be done apart from just filing the case and litigating the case.
How long do these cases usually last?
2.5 years typically to get to trial in a case. This will take a long time, I suspect. There's so many defendants. To have my paralegal has lost her mind. To have a hearing in court, I suspect that the parents and minors will be represented by the same lawyer, but I think there's 17 different sets. And so that's 17 defense lawyers and me.
Wow.
And so just the practical considerations are a little difficult, and we're trying to wrap our minds around it. But when you have that many kids going out and just beating up innocent people for literally no reason for 6, 7, 8, 9 months or more, then, and they're all conspiring to do it, and they're all going out and beating up kids and circulating it, they're all on the hook for it. And so I'm not going to let some off just because, it's tough to put a 19-person Zoom call together.
Sure.
If that's possible. I don't even know if it's possible, but
But
we'll
let me go
figure it
back
out.
to my question, because can some defendants settle by providing information that would help the case, or no?
No.
Okay. So it's very different than criminal law. You can't make a plea.
Well, if someone wants to settle out of the case, I consider it, but it's not going to
Okay.
be contingent upon anybody turning or providing information or anything like that.
Because you have everything you need. So you don't need any more information.
Yeah. I mean, if they provide me information, I'm happy to receive it, but I'm not going to give anyone, I'm not going to let anybody out of the case because they agree to turn.
Okay.
I'll take depositions and I'll get all the information that I can and work the case and make it as strong a case at trial as I can. And along the way, if anybody wants to try to settle the case and get out of it, we always do that. It's for the best interest of our clients, and for the case itself. And we typically don't file these cases. There's a point to them, and we want justice, and justice comes in the form of settlement often.
Right.
And so if one of the insurance companies wants to finance their way out of a case, we consider it like we do in all of our cases.
In these cases, you have listed the minors. Their names are not protected. It's not confidential. That's very different than what we're seeing in the criminal case. Can you explain that?
Yeah, we have no restriction on naming minors. We simply don't. There's no court rule that limits us from doing it, and so we could, but these are not innocent kids. These are teenagers that know good from bad. They know right from wrong, and they were going out and assaulting people. It's not like, a 16-year-old gets his driver's license and accidentally blows through a red light and kills somebody. We might John Doe that kid just out of respect. But these kids were going out and assaulting and attacking others for no reason whatsoever and gloating over it. And it was always, 8-on-1 or 6-on-1 or 4-on-1. That, trust me, none of those goons would have taken on Rick's kid, who was, 6'3" and an athlete. And the only way that attack happens is if it's 8-on-1 or 6-on-1. They were taking advantage of kids, and there's no good in that. I can't wrap my mind around human beings doing that to one another. So I named them.
Thank you so much for coming on the show. Moreover, thank you on behalf of all of us citizens who really, really, really want to see justice. And thank you for being the person to make that happen.
Well, you're welcome. I love these cases. I love what I'm doing, and I hope I can get some justice for my clients.
Thanks so much for listening to the Modern Divorce Podcast. Remember, anything you've heard today or anything you read online is not the replacement for actual consultation with an attorney and does not create an attorney-client relationship. Even if you called in and we spoke to you, you were anonymous and we don't have your details and you have not become a client of Modern Law. However, we would love to speak with you, or you should seek out the advice of legal counsel or counseling or any other expert near you. And if you have an idea for a show topic or you need to speak with an attorney in Arizona, you can reach me at info@mymodernlaw.com.